Defendant Kenneth J. Curry, is that your name, sir?
Yes, sir.
He's present before the court, and he's not accompanied by anybody right now. Mr. Perdue, I think I had your name on this case. Would you be willing to take an appointment on these?
Yes, sir. I was going to ask you to do it, but the gentleman that says that he doesn't want a lawyer, that's why he didn't come.
I ain't did nothing wrong, but I need a lawyer for it.
Well, I think if you did nothing wrong, you probably need a lawyer to get yourself exonerated and get out of jail. Mr. Curry, we're trying to handle your case. We're trying to protect your criminal rights, and we're trying to move this case along. Now, I've been advised that you've refused to file an affidavit.
I'll say so.
And now let me finish. If you're not going to file it, what I'm going to do is I'm going to send you back over to the county jail, and we're going to do you last because you're going to take some time. Now, if you're not employed, if you don't have any income, you sign an affidavit indicating that you don't have the money to hire a lawyer. I'm prepared to appoint Mr. Perdue to represent you. If you're innocent and should be exonerated, you need an attorney to help you. It's going to take more than to just sit here and say, I'm not guilty.
We have his cuffs removed, Your Honor, so we can do that, please.
Yeah, he can sign. Court will appoint Mr. David Perdue to represent him at state expense.
When Sarah George resided, we believe that due to the severity of his actions by allowing a murder suspect when he knew that a murder had taken place to hide out and to conceal his whereabouts, knowing that he was being sought after, substantiates a $5,000 bond, 10% cash.
If the court sets a personal recognizance bond, and if you don't show up on the personal recognizance bond, you commit another felony offense. And believe me, they're hard to defend. I don't know how you convince a judge or a jury you were in court when you weren't here. So the conviction rate is probably about 100% on failure to appear cases. This is a nonviolent charge, obstructing justice. It's a serious charge, especially if the state proves, but there is a presumption of innocence at this time. I don't think it's necessary to hold these people in jail until these trials come up. So I'm going to set a bond in this case, and I'm going to set bond the sum of $25,000, personal recognizance. Now, let me tell you a little bit about the personal recognizance bond. Everybody else can listen too. And all a personal recognizance bond is, basically, is a promise to appear. If you don't keep that promise, and if you don't appear, on the date of your non-appearance, the court's going to issue a warrant for your arrest. The warrant's going to go into a national computer. You're going to owe the state of Ohio the face amount of the bond. In your case, it'll be $25,000. You're probably going to be indicted by the grand jury on a new felony offense of failure to appear. I believe that's a felony of the 4th degree. It carries a maximum sentence of 18 months. Because it's your responsibility to keep your attorney notified on how you can be reached. Sarah Lynn George, in this case, the defendant, has also been indicted on one count of obstructing justice. My form says a felony of the 5th degree, but I believe it's a felony of the 3rd degree.
It is.
Present before the court in this case is the state of Ohio. It's represented by prosecuting attorney Nicholas Hiroshi. The defendant, Sarah Lynn George, is that your name, ma'am? Is present before the court. He's accompanied at this time by attorney Christopher Bowman. Do you have the financial ability to hire an attorney to represent you in this case?
ORAS report. My client scored a 1 on the ORAS report. And that was for being under 33 years of age. She's 29 years old. I think she's of minimal risk. She has custody of her 9-year-old daughter. I think she's of minimal risk, has no criminal history to speak of other than speeding and a seatbelt violation. Prosecutors asked for pre-trial services. We would ask that my client not be ordered to do pre-trial services. Like I say, her ORAS score was 1, and that was for being under 33 years of age.
Your Honor, just to be consistent with the other case involving Mr. Curry and the one that's coming up with Ms. Northwest, we'd ask that a $5,000 cash surety, 10% bond be issued for the same reasons that apply to Mr. Curry's case. And pretrial services is recommended, as noted by probation under form. Yes, the score is only 1, but the court has indicated today that it's accepting the recommendation of pretrial services despite the low score. We do believe due to the severity of the charge that she would be a good candidate for pretrial services.
In order for this court to be consistent also, I think I just set a $25 PR bond on a gentleman that had a prior felony conviction. I know because he's on post-release control. It's not been represented here that Ms. George has any prior criminal record or as score is 1. I'm going to give her the same benefit. I'm going to set a $25,000 personal recognizance bond. Upon posting that bond, you may be released from custody. And I believe you were present here a few moments ago when I indicated what the consequences are of not appearing on this bond. Although you only have to sign a piece of paper and promise to appear, the consequences are really severe if you don't show up. All right, well, I'll take up 2014 CR 548, Ohio versus Nicholas Roman Quarterman. In this case, it appears the defendant's been indicted on 1 count of tampering with evidence, a felony of the 3rd degree. Present before the court is the state of Ohio. It's represented by prosecuting attorney Nicholas Irochi. The defendant, Nicholas Roman Quarterman, is that your name, sir?
Yes, sir.
Is present before the court. He's accompanied at this time by Public Defender Dean DePaula. You've listed an employer here as, that's what, a part-time employer?
Yes, sir. I was supposed to show up today. He said if I couldn't make it today.
All right, but you work part-time, you don't have a regular income.
No, sir. I don't have none. No. I didn't make it today, so.
All right, the defendant indicates he works part-time. The court will appoint the public defender's office and attorney Maria Lane of that office to represent the defendant at state expense. All right, you want to be heard on the issue of bond.
Your Honor, like the other previous co-defendants, Mr. Quarterman is charged with tampering with evidence. From reviewing his CORAS and pretrial services, he does score low at 2. Although the indictment has a Cleveland address, Mr. Quarterman has listed on his affidavit and from his interview that he does live in Ashtabula. He actually lives with one of the other co-defendants. We do not feel he would be a flight risk. We believe that he provided phone numbers, a good address that he will appear for all future court dates. The bond is modified to that of a personal recognizance bond.
Due to the fact that it's a tampering, it's not a violent offense, the court will set a bond, and I'm going to set it in the same area that I set it for the other obstruction of justice or tampering cases. We'll set it at $25,000 of personal recognizance. Were you present in the courtroom when the court went over the consequences of not appearing on a personal recognizance bond?
Yes, sir. I heard you.
You understand that if you don't show up on that bond, you could be charged with another felony offense. Ohio versus Carlin, is that how you pronounce your name?
It's Carlin, and it's not Ruth, it's Owens.
Well, you've been indicted under the name Ruth.
Speak up, please. I can't hear you.
I said that was only to show that Germaine is my son. My last name is Owens.
Owens?
Yes.
All right. All right, we didn't know if you had an attorney or not. The court took the liberty of contacting Mr. Shiflett and asking him if he would accept an appointment if you consented to it. So would you like to have the court appoint Mr. Shiflett to represent you in this case?
Yes, sir.
Mr. Shiflett isn't here, but the court will appoint Hobart Shiflett as counsel for the defendant. Now, have you received a copy of the indictment?
Yes, sir.
Would you like to have the indictment read?
No.
All right, and how do you plead to the charge of tampering with evidence?
Not guilty.
The court will set then bond at $25,000, be personal recognizance. Were you in court when I explained the consequences of not appearing on a personal recognizance bond?
Yes, sir.
We will set your bond at $25,000 personal recognizance. This case was previously assigned to Judge Vettel and co-defendant Carlin Ruth. She's a co-defendant of Mr. Quarterman. So both of these cases are now assigned to Judge Ronald Vettel. court has set a personal recognizance bond on all of the others. Is there any reason why this case should not be a $25,000 personal recognizance bond?
No, you're
And the bond will be set in this case at $25,000 personal recognizance. And I believe Ms. Nordquist was in the courtroom when the court went over the consequences of not appearing on a personal recognizance bond.
Yes.
Now, you were arrested on the 16th.
Yes, sir.
So you've been in jail for 3 days. Case number 2014 CR 493, Ohio versus Jermaine L. Ruth. In this case, it appears the defendant's been indicted under count 1 of the indictment on the count charge of aggravated murder with a gun specification. Under count 2, he's charged with murder with a gun specification. Under count 3, he's charged with tampering with evidence, a felony of the 3rd degree. Present before the court is the state of Ohio. It's represented by prosecuting attorney Nicholas Irochi. Defendant Jermaine L. Ruth, is that your name, sir?
Yes.
Is present before the court, and he's accompanied by attorney Jimmy Mack. Is that Jimmy Mack Jr.?
Yes, it is, Your Honor. Thank you.
Would Mr. Ruth like to have the indictment read?
No, we will waive the reading of the indictment in open court.
All right, and how does he plead to each of the 3 charges?
Not guilty to each of the charges, Your Honor.
Appears that bond has been set at $800,000 to be set by cash or commercial surety. It was set in the Ashtabula Municipal Court on August 8th, 2014. Anybody want to be heard on anything dealing with bond?
I would like to address the honorable court.
Very well.
Your Honor, we would like to bring to this honorable court's attention that my client at this juncture is asking for a reduction of the bond. Your Honor, the reason why is my client voluntarily turned himself in. The marshals were looking for him. We made arrangements for him to go in voluntarily. There was no possibility that he thought of running. And criminal rule 46 talks about the bond is set to ensure that whether or not a person will appear for court. And by the fact that he went in voluntarily, that he has retained me, and that I do believe, Your Honor, that this case, and we do have a bona fide defense, not a frivolous defense in this particular case. I would ask that a reasonable bond be set in this matter, Your Honor. I would think that maybe a $50,000 bond would be reasonable in this matter.
And due to the defendant's past history, violent history, having been convicted of aggravated assault, as well as attempted felonious assault, we do believe he poses a risk of harm to the public as a whole. So we would ask that the current bond be continued. Thank you.
In this type of charge, there is always a flight risk because of the potential penalties that may be involved in this case. So the court denies the motion to reduce bond. Bond will remain as previously said in the Ashtabula Municipal Court, $800,000 that can be set by cash or commercial surety. This case is assigned to Judge Ron Lavelle. It will be scheduled within the requirements of the Ohio Revised Code. Written notice will be furnished counsel for both parties of all hearing and trial dates. All right, now we'll go over to case number 2014 CR 94. This case is entitled State of Ohio versus Jermaine L. Ruth. In this case, the defendant's been indicted on 1 count of trafficking in heroin with a forfeiture specification. The forfeiture specification deals with a 1988 Oldsmobile motor vehicle, which is alleged was used to commit or facilitate the offense. This trafficking in heroin is a felony of the 5th degree.